Welcome to the Mandamus Lawyers Podcast, a legal education series about federal court remedies for immigration delays. I'm Mary, and I'm here with my co-host, Aaron. Today we're discussing what steps you can take to resolve an immigration delay before filing a federal lawsuit.
This is an important topic because mandamus litigation, while effective, isn't always the first step. There are administrative options that may resolve your case without going to court. And even if those options don't work, attempting them can strengthen your eventual lawsuit.
So this episode is about what to try before you sue.
Exactly. We'll cover the main administrative channels available, how effective they tend to be, and how to document your efforts so that if you do need to file a lawsuit, you have a clear record showing you tried to resolve the matter through other means.
Let's start with the basic question. Why try anything else if mandamus is so effective?
Several reasons. First, some delays can be resolved without litigation. If a simple inquiry or escalation gets your case moving, you've saved time and money. Not every delay requires a federal lawsuit to fix.
What's another reason?
Second, attempting administrative remedies creates a record. When you file a mandamus lawsuit, part of your argument is that the delay is unreasonable and that you have no other adequate remedy. If you can show that you tried multiple channels and none of them worked, that strengthens your position.
Does the law require you to exhaust these options first?
Generally, no, not in the formal legal sense. Courts have recognized that exhaustion requirements don't apply the same way in delay cases because there's no decision to appeal. But as a practical matter, making some effort to resolve the delay before suing is advisable and demonstrates good faith.
Let's go through the options. What's the first thing someone can try?
The most basic step is submitting a case inquiry directly to USCIS. This can be done through the USCIS online account system. If your case is outside normal processing times, you can submit an inquiry asking for a status update or an explanation for the delay.
How effective is this?
Results vary. Sometimes an inquiry prompts the agency to take a closer look at a case that fell through the cracks. Other times, you receive a generic response saying the case is still pending and to continue waiting. The effectiveness depends on why the case is delayed and whether the inquiry reaches someone who can actually move things forward.
What should someone include in a case inquiry?
Be specific. Include your receipt number, the date you filed, and a clear statement that your case is outside posted processing times. If there are specific circumstances causing hardship, family separation, employment issues, inability to travel, mention them. The more concrete information you provide, the better.
What about calling USCIS directly?
You can contact the USCIS Contact Center by phone. The representatives can look up your case status and, in some situations, submit a service request on your behalf. A service request is essentially an internal inquiry that asks the office handling your case to provide an update.
Is this more effective than the online inquiry?
Not necessarily. The contact center representatives have limited ability to influence case processing. They can see the same status information you see online and can escalate certain issues, but they cannot make decisions on cases or direct officers to take action. Many applicants find these calls frustrating because the answers are often vague.
So it's worth trying, but expectations should be modest.
Correct. Document the date and time of your calls, what you were told, and any reference numbers you receive. This creates a record that you attempted to get information and were unable to obtain meaningful answers.
Can applicants visit a USCIS office in person?
USCIS offers appointments at local field offices through a system that has changed over time. Previously called InfoPass, in-person appointments are now generally scheduled through the USCIS online account or contact center. Availability varies by location and by the type of issue.
What can you accomplish at an in-person appointment?
It depends on the nature of your case. For some issues, like biometrics problems or document questions, an in-person visit can be helpful. For general processing delays, the field office staff may have limited ability to help because the case might be pending at a service center rather than the local office.
So the value depends on where the case is actually being processed.
Right. If your I-485 is pending at the Texas Service Center and you visit your local field office, that office may not have direct access to your file. They might be able to submit an inquiry on your behalf, but they cannot adjudicate a case that isn't assigned to them.
What about contacting elected officials?
Congressional assistance is one of the more effective administrative options. Every member of Congress, senators, and representatives has staff dedicated to helping constituents with federal agency issues, including immigration. You can contact your representative's or senator's office and ask for help with a delayed case.
How does this work?
The Congressional office will typically ask you to sign a privacy release, authorizing them to inquire on your behalf. They then contact USCIS through official channels. Congressional offices have dedicated liaisons at the agency. The inquiry asks USCIS to explain the status of the case and the reason for delay.
Is this more effective than contacting USCIS yourself?
Often, yes. Agencies tend to respond to congressional inquiries with more attention than routine applicant inquiries. A congressional inquiry doesn't guarantee action, but it can prompt a more thorough review of why a case is delayed. Some applicants have seen their cases move forward after congressional involvement.
Any limitations?
Congressional offices cannot force USCIS to approve a case or make a decision by a certain date. They can advocate and inquire, but they don't have legal authority over the agency. Still, it's a valuable option that many applicants overlook.
What is the USCIS Ombudsman?
The Office of the Citizenship and Immigration Services Ombudsman is an independent office within the Department of Homeland Security. Its role is to assist individuals and employers in resolving problems with USCIS and to identify systemic issues in the immigration system.
How can someone use the Ombudsman for a delayed case?
You can submit a case assistance request to the Ombudsman's office. They will review the situation and, if appropriate, contact USCIS on your behalf to seek information or resolution. The Ombudsman serves as an independent check on the agency.
How effective is this option?
The Ombudsman can be helpful, particularly for cases involving unusual circumstances or apparent errors. However, the office has limited staff and receives many requests, so response times can be slow. It's another tool in the toolbox, but not a guaranteed solution.
When is the Ombudsman most useful?
When there appears to be a specific problem, a case that's fallen through the cracks, a systemic error, or an unusual situation that doesn't fit normal processing channels. For routine delays caused by general backlogs, the Ombudsman may have less leverage to help.
Can applicants request that USCIS expedite their case?
Yes, USCIS has criteria for expedite requests, and applicants can ask the agency to prioritize their case based on specific circumstances. The criteria include severe financial loss, emergencies, humanitarian reasons, nonprofit organizations with urgent requests, U.S. government interests, and USCIS error.
How do you submit an expedite request?
Expedite requests are typically submitted through the USCIS Contact Center, or, for some case types, through the online account. You need to explain which expedite criterion applies and provide supporting documentation.
How often are these granted?
USCIS does not publish approval rates for expedite requests, but anecdotal reports suggest they are granted selectively. The agency has discretion, and simply being frustrated with processing times generally doesn't qualify. You need a specific, documented reason that fits the criteria.
So this is worth trying if you have a qualifying circumstance.
Definitely. If you have a genuine emergency, a serious medical situation, imminent job loss, urgent travel need, an expedite request is appropriate. Document everything thoroughly. Even if denied, you've created a record showing you attempted to resolve the urgency through proper channels.
You've mentioned documentation several times. Why is that so important?
Because if you eventually file a mandamus lawsuit, your complaint will describe the efforts you made to resolve the delay. Judges want to see that the plaintiff tried to work with the agency before turning to litigation. A well-documented history of unanswered inquiries, unhelpful responses, and failed escalations supports the argument that litigation is necessary.
What should applicants keep track of?
Everything. Dates of online inquiries and the responses received. Dates and summaries of phone calls, including representative names or ID numbers if provided. Copies of correspondence with congressional offices. Expedite requests and their outcomes. Any communication with the Ombudsman. Screenshots of online case status showing no movement over time.
How should this be organized?
Keep a chronological log. Date, action taken, response received. Save emails, letters, and screenshots in a folder. If you work with an attorney later, this documentation will be valuable for drafting the complaint and demonstrating the history of delay and failed resolution attempts.
How do you know when it's time to stop trying administrative options and consider litigation?
There's no bright line rule, but several indicators suggest administrative options have been exhausted. You've made multiple inquiries over an extended period and received only generic responses. Congressional assistance hasn't produced results. The Ombudsman hasn't been able to help. An expedite request was denied or ignored. Months continue to pass with no movement.
Is there a point where continuing to try is counterproductive?
Potentially. If you've been making inquiries for a year and nothing has changed, additional inquiries are unlikely to produce different results. At some point, the pattern is clear. Administrative channels aren't going to resolve this case. That's when litigation becomes the appropriate next step.
Should someone continue administrative efforts after filing a lawsuit?
Generally, no. Once litigation begins, communication with the agency typically goes through the attorneys. Continuing to submit inquiries or contact congressional offices can complicate matters. Let the litigation process work. It creates its own form of pressure and accountability.
Even if administrative options don't resolve the case, is there value in having tried them?
Absolutely. First, you might get lucky. Some cases do get resolved through these channels. Second, you build a record that supports your lawsuit. Third, you demonstrate to any future court that you acted reasonably and gave the agency opportunities to fix the problem before suing.
Does trying these options delay filing a lawsuit?
It can, but the delay is usually minimal if you're strategic. You can pursue multiple channels simultaneously, submit an online inquiry, contact your congressional representative, and consider an expedite request all around the same time. You don't have to wait for one to fail before trying another.
So it's not necessarily a sequential process.
Right, and if your case has already been pending for years, you likely have a documented history of waiting, even if you haven't made formal inquiries. The key is to have some record of attempting resolution before filing suit, not to spend additional years exhausting every conceivable option.
Let's summarize the key points from this episode.
First, before filing a mandamus lawsuit, there are several administrative options worth attempting. These include USCIS case inquiries, contact center calls, congressional assistance, the USCIS Ombudsman, and expedite requests for qualifying circumstances. While not legally required, these efforts can sometimes resolve delays and create valuable documentation if litigation becomes necessary.
Second, congressional assistance is often one of the more effective options because agencies tend to respond more attentively to congressional inquiries. The Ombudsman can help with unusual situations or apparent errors. Expedite requests may be granted if you have documented circumstances meeting USCIS criteria.
Third, document every effort you make, dates, responses, outcomes. This record supports your eventual lawsuit by demonstrating that you tried to resolve the matter and that litigation is necessary because administrative channels failed. When those channels consistently produce no results over an extended period, it's time to consider federal court action.
Thank you for listening to the Mandamus Lawyers podcast. Mandamus Lawyers is a law firm focused exclusively on federal court litigation for immigration delays. Visit mandamuslawyers.com.